Defending audits and enforcement actions by the government in the immigration area can be itself quite complicated. Department of Labor investigations typically involve an investigator who will come over. Of course, they try to give you 10-day notice or a 7-day notice. They will come over to review certain documents that you are required to maintain under public disclosure. The thing that you got to watch out for is the investigator is given a lot of power about their decision making. They review the paperwork, and it can take, typically under the regs, it's supposed to take a certain amount of time, but invariably it stretches. So a year, 2 years for an investigation is not uncommon. Some of the cases that we've given will show you the techniques used by the Department of Labor investigators. Some of them I find very objectionable, frankly. But as a practitioner, you have to be careful about right to counsel. You may not have a right to counsel everywhere you want to go. Okay, these are benefits. These are not necessarily areas that are protected by Constitution with the right to counsel. So most of the times we can, if not insist, at least very politely and firmly ask to be present. And Department of Labor doesn't decline those things. The rules of adversarial litigation don't quite apply here, because in an adversarial litigation, we take the approach that we are going to fight everything. Not so when you are dealing with audits and enforcements. Your willingness to comply and to supply the information, reasonable information asked, goes a long ways towards predisposing the investigator in your client's favor. It also goes towards calculation of civil money penalties, and it goes towards showing your intentions. Reading the DOL cases that we have attached for your review, you will see that thread. If you read into the cases, as you all would, you will see that there is a thread that shows, did this employer consult counsel? Did this employer have a pattern or practice? Did this employer cooperate? So we have a very interesting situation where we are a mediator as well as a litigator when dealing with audits. We are trying to make sure, I don't remember declining too many requests made by the Department of Labor. The last one I absolutely refused to comply with was a request made by a Department of Labor investigator. I think it was in Illinois. It was in the Illinois area. They asked for all emails relating to a certain employee, and I said, no, we're not going to do that. We're not going to supply you that because it's irrelevant. What you're asking for is way overreaching what you have been charged with. So I declined. But you got to pick and choose those very carefully, and only after a very careful consultation with your client. So when you deal with an audit defense or an enforcement defense, depending upon the agency and the level and the types of charges you're dealing with, your entire approach must change. Okay, if you look at the bottom of this slide, you will see the DHS ICE investigations. The rule of the thumb is to get criminal defense lawyers. That's a different kind of investigation. Okay, there you cannot handle it if you're not a criminal defense counsel yourself. You've got to get somebody who knows what they're doing, because you will eventually end up with some kind of a criminal indictment. And we've helped a bunch of companies defend themselves against criminal indictments. Time permitting, I would like to talk about that as well. So going back to the audits, make sure you understand this is not an adversarial proceeding necessarily. It is, but you've got to be careful. Then there's an interesting DOJ investigation for discrimination. Here also you can get debarment and fines. Recently, DOJ fined an employer, Microlink Devices, for making US citizenship a requirement for their jobs. This company was a government contractor on projects that had some implication of international traffic norms, ITAR regulations. And consequently, the company was limited to hiring only US persons to work on the contract. DOJ noted, ITAR does not require or permit employers to limit job applicants to or prefer US citizens in the hiring process. Moreover, restricting hiring to US citizens runs afoul of anti-discrimination provisions in the Immigration and Nationality Act that apply not only to US citizens, but also to US nationals, permanent residents, which is green card holders, and certain refugees and asylees. So the definition of US worker is a lot broader than you would normally through common sense think. And in DHS ICE investigations, this is another very weird area of the law. Again, I hope I have enough time to talk about it. But I want to begin by saying this is a trap for the unwary. This is a trap for the unwary, for the innocent. Why? It is common for DHS, ICE, or even State Department to send investigators who approach the employer very innocuously. They'll say, well, you know, you filed an application for this and this, and we just want to know a little more about it. Next thing is you've got a joint task force from FBI and various government agencies knocking at your door, and the next thing is you're stuck with a 50-count indictment. So what you thought, and they don't need to Mirandize you when they are talking only about benefits. As they discover more and more information, that's when the criminal aspects begin. So I, as a practitioner of immigration law, I am very careful. I know when I need to get somebody from the criminal defense area involved right away. Keep this in mind when you're defending audits and enforcement actions.